Hello guys, welcome to this video. Today we are going to be looking at the types of contracts. So we'll start first of all by looking at the types of contracts on the basis of validity. So the first type of contract on the basis of validity is a valid contract. In simple terms, a valid contract fulfills all the provisions of validity that are required by the law. Secondly, we have a void contract. A void contract is a contract that was legally enforceable when entered to, but has become void due to the ongoing circumstances. For example, if a country such as Kenya is fighting with Somali, and the government of these countries prohibit and proscribe any form of contractual engagements between its citizens, the contracts that were legally valid or that were formed legally before the war will become void. So we also, on the basis of validity, we have voidable contract. So these voidable contracts are contracts that are valid until it is repudiated by the party that is entitled to avoid it. For example, if you make a contract with a child, the child may enforce that contract against you, but you cannot enforce that contract against the child, because the child can ask the ability to repudiate it. So that is a voidable contract. We also have, on the basis of validity, an enforceable contracts. In simple terms, an enforceable contracts, these are contracts that are valid but cannot be enforced due to some technical defects. So this means that the contractual parties, for example, failed to make a signature in such technical matters that really make a contract invalid. So we have finished looking at the types of contracts on the basis of validity. Secondly, we are going to look at the types of contract on the basis of formation. So in this category, we have one, express contracts. The express contracts are the contracts that are formed by words and in writing. So they have express terms such as sentences, paragraphs, and clauses. Secondly, we have implied contracts. So implied contracts are not necessarily written down or oral, but are reflected in the behavior of the parties. For example, when you are in the road and you look at the traffic lights, when the green light shines, you cross the road as quickly as possible. Or when you see an image with a person walking, you cross the road instantly. There is no contract, but that is implied because of that what I have told, behavior of parties. So we also have constructive or quasi contract. These are contracts that are imposed by you by the law. When the parties, of course, you had no intention to create a contract, but because the law enforces it to you, you find yourself in a contractual setting whereby you have to release consideration to another party. For example, you may get into this kind of constructive or quasi contracts when you do a tort. For example, let's say you hit someone on the road due to maybe it was an accident. The law may impose upon you the contract or a contractual obligation to pay. Another example whereby we seek constructive or quasi contracts a lot are situations involving couples. Sometimes the law may impose upon you to pay certain amounts of money to the wife for child keeping and child safe guarding. So those are quasi or constructive contracts. The third criteria that is used to classify contracts is called performance. And on the basis of performance, we have 4 types of contracts. So we have number 1, executed contracts. Both parties have performed their contractual obligations. For example, I go to the store, I get a good, I pay and get the good from the store. So I have paid, and I have also, the storeman or the someone who is in charge of the store has handed me the goods. So that is a complete contract. That is an executed contract. On the basis of performance, we also have executory contract. This is where the contract is yet to be performed fully or in part. So executory contract, the parties have not yet discharged their contractual obligations. So thirdly, we have what we call unilateral contracts. So unilateral contracts are contracts where one party in the contract has fulfilled its commitments, while the other party is yet to do it. So unilateral contracts in most cases are seen or appear to be really promises coming from one party, and if you adhere to a certain set of behavioral expectations, most likely they will honor their contractual obligation. So unilateral contract, we have to note that the most important thing is that one party in the contract has fulfilled the commitment, while the other party is yet to also fulfill the commitment. The fourth type of contract on the basis of performance is what we call bilateral contract, and this one is simply where both parties fulfill their commitment simultaneously. They work, they fulfill what they agreed, and when they are in ad idem, or what is called one mind. So once parties fulfill their commitment simultaneously, that is called bilateral contract. Thank you for watching this video. Like, share and subscribe. Don't forget to leave a comment below, and if you have any question, kindly leave it on the comments section. I will be very glad to really help you, especially in the journey of law, in understanding and mastering the legal affairs. Thank you for watching this video.